For those who don't know me, my name's Kurt Vest, and I'm the enforcement engineer for the division. I've been that for about 2 years now. Prior to that, I was the regional engineer down in Cedar City for 10 plus years. Glad to be with you here today, I guess. I have an issue I need to talk to Ken about, though. I have a vehicle that keeps stalling on me. And I made 2 stops on the way up, run just fine. Then I got here and started filling up gas, and it stalled, so it was sitting at the gas pumps, and I couldn't get it to start again, so I really need a new vehicle. Or why couldn't it have stalled at the other stop so that I didn't have to do this? Okay. To begin with, I'm going to start talking about enforcement. Most of the enforcement violations I deal with have to deal with irrigation. However, there's a variety of things that that enforcement covers. This is the way we used to do enforcement. When I first started with the division, we had almost zero authority to deal with those who were violating the water right. In fact, the only authority we really had was to take them to court and sue them, which I'm aware we did that in 2 cases in the Milford Valley. Other than that, I'm not aware that we ever did that. Then, about 2005, the law changed and gave the state engineer some administrative enforcement powers. Now, don't get mistaken, I am not this guy right here, okay? A lot of people think I'm the water cop. I don't carry a gun, I don't carry a badge, and my powers are administrative, okay? However, the state engineer now has pretty significant power to deal with enforcement. In 2005, that law was enacted, creating the enforcement program. With that program, we can now deal with people who are diverting and pounding using water without a water right. We can deal with people who are diverting and pounding and using water in violation of an existing water right. We can deal with people who have faulty controlling works or measuring devices. We can deal with people who are wasting, polluting, or contaminating water. We can deal with people who go against orders of the state engineer. We can deal with people who relocate or alter streams. We can go after people who violate orders regarding dam safety. And also we can go after well drillers who aren't following their rules, and also go after people who are drilling wells without a license. To commence an enforcement action, after investigating the issue, I prepare what's called an initial order. This initial order outlines the violation that's taking place. It identifies penalties that they are subject to because of the violation. And it also notifies them that each day can be considered a separate offense. By the way, if anybody has any questions as we're going, don't feel afraid to raise your hand. Through this enforcement process, once a final order is prepared, we can administratively fine up to $5,000 a day for a knowing violation, or $1,000 a day for a not knowing violation. We can force the violator to replace up to 200% of the water taken, and we can force the violator to pay the state engineer's cost for investigating and stopping the violation. And as I said, each day constitutes a separate violation. One thing we cannot do, though, is we cannot go back in time beyond 12 months. So that violation had to have occurred within the past 12 months. Before we impose a fine, there are some things that the law requires that we take into consideration. First of all, we need to look at the value of the water that was taken. We need to look at the gravity of the violation, look at the economic injury or impact to others. We take into account whether the person was cooperative with us and attempted to comply with our orders. And we look at the economic benefit that the violator gained through the violation. In determining all those things, there's a set of administrative rules that I look at that kind of is my guide when I'm calculating the fines and the things that pertain to that. There's a pretty extensive set of rules, 25 pages of single-spaced information there that give me direction on how to handle that. That rule is R655-14. Okay. That being said, typically I take a little different approach to enforcement. In the 2 years that I have been the enforcement engineer, I've had to actually find one person. Okay? The approach that we typically take now is when I investigate a violation, I will typically write a letter to that person and notifying him of what I found, of the alleged violation. I tell him, I prepare what's called a notice of violation, and I tell that individual, you know, you may be subject to fines here. Typically, I get that person to come in and work with me. And in all cases but one, I've been able to resolve that issue, get them back into compliance without having to drag them through the enforcement process. The one that I did find was a repeat offender, and that's kind of the approach I'm taking is for a first-time offense, I will work with you, try and get you in compliance. Now, we do have authority to fine you on a first offense, and if the case justified it, we would have to look at that, but typically, we just want to get compliance. And as long as you stay in compliance, you should be good. If you repeat, that's when we will probably hit you. Any questions on enforcement?
In that first, you mentioned something about stream alteration. What happens if they take water out of a creek, but it changes its course, and they go in and try to divert the water back to their head gate? Is that Army Corps of Engineers type thing, or are they allowed to go get their water?
Anytime you alter the bed or banks of a stream, you need a stream alteration permit first. And I'll talk about that in a minute, stream alteration. But we, with enforcement powers that we do have authority to go do what we need to get in compliance on the stream alteration. If there's repairs or things that needs to be done to put it back or whatever we need to do, we have that authority. Okay, and if I haven't totally answered that, when we cover the stream alteration section, if you have more questions on that, we can follow up there. Any other questions? Okay, let's move on to dam safety. This picture here kind of brings back some bad memories for me. Why are you laughing, Clark? I think it was back in December of 2010, we had a significant rain event down in southwestern Utah. This is South Creek Dam, which is a tributary, located on a tributary to the Virgin River. We got notified that the dam was about ready to fail. And so myself and Nathan Moses hopped in the vehicle, started driving down. We met a helicopter at Anderson Junction, and they flew us into the site. This is actually a picture we took from the helicopter as we were looking at what was happening to this dam. We later flew around, sat down on the dam itself, and proceeded to investigate. After investigating it, we kind of realized what was happening was the kind of overburden on the dam was saturated and sloughing off, but the core of the dam itself was intact and not threatening to fail. We got back into the helicopter. I thought they were going to take us back to our vehicle, but no, they flew us to St. George, to the county administrative building, and they wouldn't take me back to my vehicle unless I held a press conference. Basically held me hostage. They wanted me to tell them, and prior to that, they had evacuated the towns of Rockville and Virgin. And they wanted me to make a decision and tell them whether they could send residents back or not. And I said, well, that's really your call. Anyway, after we had the press conference, they took me back to the vehicle, and that night I kept having nightmares that I made the wrong call and that dam failed and killed hundreds of people. I was very glad when I woke up the next day to find that the dam was still intact. And what they didn't tell me is that one of the motels there had put up everybody in the motel so nobody went back to their homes anyway. But that's some of the issues we deal with dam safety. In 20 years of inspecting dams, one thing that I've realized is there are a lot of dams in the state that are in bad repair or disrepair, that are in pretty bad condition. Thankfully, most of these dams are small in nature. Most of the larger dams are in good repair and well maintained. But a lot of the smaller dams, the owners just don't have the resources to make the repairs and keep up on them. So we, through the dam safety program, are dealing with those issues. Okay, the state engineer has power to regulate dams. The state engineer can make rules controlling the construction, operation of dams, including the design, maintenance, repair, removal, and abandonment of that dam. The state engineer may exempt any dam from filing formal plans if that dam impounds less than 20 acre-feet, and if it were to fail, would not threaten human life. Also, any dam that would not threaten human life if it fails and would cause minimal damage can also be exempt from that. Anybody who is designing a dam must be licensed in the state of Utah and be experienced in dam design and construction. Written approval must be had from the state engineer prior to commencing any work on that dam. Dams are classified according to hazard and use. A high hazard dam is one that if it were to fail would likely cause loss of human life and extensive economic damage. A moderate hazard dam is one that, if it were to fail, may not cause loss of human life, but it would cause significant property damage. And a low hazard rating is one that, if it were to fail, would not cause, or the threat of causing loss of life is low, and the damage would be minimal. As far as uses, the main use of dams in the state is for water storage. Next to that, probably there's flood control. There's a lot of flood control structures throughout the state. In mining operations, there's dams for tilling ponds. We have stock ponds, diversion dams, and regulating reservoirs. Okay, before a dam is constructed, plans must be submitted to the state engineer. These plans must be submitted 90 days prior to awarding the contract for construction or prior to the actual commencement of that construction. If plans are not required for the construction of a dam due to the size or nature of that dam, you still need to file an application with the state engineer. We have what's called a small dam application. And so whether or not you have to submit formal plans or not, you still need to file an application with the state engineer, whether you're building a stock pond or a large storage facility. An application needs to be filed. The state engineer has to have an opportunity to review those smaller applications and to evaluate the hazard rating and whether or not water rights are covered for that facility. So, and one thing that I find a lot is people pretty well get approval for the large dams. They go through all the process, but there's a lot of little small ponds that are created throughout the state that shouldn't be created. In fact, next to dealing with illegal irrigation, probably the next thing that I deal with the most is people who create small ponds without getting authority. So keep in mind, you do need a water right for a small pond, and you do need to submit a small dam application and get approval before you build that facility. The state engineer has authority to inspect dams. Typically, the state engineer inspects dams that, if they were to fail, would pose a threat to human life, and dams that would cause significant damage if they were to fail. These inspections occur varying increments, but at least once every 5 years. Okay, once the state engineer inspects the dam, he can issue an order that would require any engineering studies, repairs. He can impose storage limitations on the facility. He can require removal of the dam or breaching the dam. That maintenance that is required, that responsibility rests with the owner of the dam. Okay, before we leave dam safety, any questions on dam construction or dam safety? Yes.
You said the application was necessary for small dams. Is there a cutoff date when existing dams were grandfathered in and don't need to be in your database?
The answer would be no, there's not a cutoff date, but there should be a water right associated with those old structures. A lot of year old regulating ponds that were part of the system, we recognized that they had been in existence. We typically don't deal with those. We realize that you know, the irrigation company has a regulating reservoir that has been there as long as the ditches has been there. We typically wouldn't do anything with them. It's those that have been constructed recently without going through that process.
For maintenance purposes, is there anything that needs to be done?
If the dam is large enough that it's on the inspection list, then we would review that. Typically, if it's a low hazard dam, less than 20 acre feet, we probably would not be inspecting that. And so it's totally up to the dam owner there. Any other questions? Yes, over here.
So anybody that creates a pond of any size must go through the process?
Yes.
All right, I just wanted
Yes.
to clarify that.
Okay, now let me clarify also on a pond. If the pond is just dug out and there's no raised embankment, no, you don't need file a small dam application, but you do have to have a water right to cover the storage in that facility. Where you need to file that small dam application is if you have a raised embankment, that we need to review that hazard rating on that. Okay. Any other questions? Okay, let's move on to stream alteration. Hopefully, if I didn't fully answer that question before, we can get back to that. Okay. All right. I like this picture here. It's always been a favorite of mine. Anybody see something that is probably not right there? What's that? The Detroit riprap. Yeah. Yeah, Detroit riprap is probably not an approved riprap. But it has been used a lot in the past. Okay. Obviously, if you're going to divert water from a stream, you need a water right. In order to facilitate that diversion, you need a stream alteration permit. Anytime you disturb the bed or banks of the stream, you need a stream alteration permit. Okay? Anytime you disturb the bed or the bank of a stream, you need that permit. We require a permit from the state, but through the Clean Water Act, the federal government also requires permission in some cases. First of all, let's define what constitutes a stream. Any stream that has water flowing in it all the time or has riparian vegetation associated with that channel is constituted a stream, and you would need to file a stream alteration permit. If it's a dry wash that just has water in it during a rain event, no, you would not need to file a stream alteration permit. But if it does contain water year-round or have riparian vegetation associated with that, then you do need to file that permit. Okay. The stream alteration permit has a fee associated with it that, depending on who you are, will determine how much you pay. Non-commercial applicants pay a $100 fee. Government entities pay a fee of $500, and commercial applicants, the fee is $2,000 for a stream alteration permit. That stream alteration permit will give notice to the state and federal agencies of your intent. Typically, the response time is less than 30 days. Typically, they can get an approval out between 20 to 30 days of when that is filed. The criteria we look at on a stream alteration permit is, first of all, it can't impair any vested water rights. The activity cannot adversely affect public recreation or stream environment. It cannot endanger the aquatic life in the stream, and it cannot diminish the natural capacity of the channel to transmit water. A stream alteration permit does not grant authority to trespass on private ground. It does not, in some situation, grant other permits that may be necessary, say through federal agencies, access through BLM, so and so. Also, it does not relieve you of any liability or damages that may take place through those alterations. The state permit can be filed as a joint permit. We have been granted authority through the Corps of Engineers to review those cases, and when appropriate, it can be approved as a joint permit. In some cases, the Corps may have some issues that they needed to address separately, but in most cases, filing that stream alteration permit will handle both the state and the Fed requirements. If you fail to get a stream alteration permit, you can face enforcement, and that's, I believe, your question there when we were talking about enforcement. However, the state does allow for some after-the-fact correction. For instance, if we have a flood event and emergency measures need to take place to protect, facilities or structures downstream, you can go in and make those alterations and then work with us afterwards to make sure things are done properly to ensure that the bed and banks are protected there. So in those emergency type situations, yeah, you can work with us after the fact. Any questions on stream alterations? Yes.
What about, like if you have an existing structure, a diversion point, and you need to go back in and maybe rebuild it or change it? Do you
Good
need a
question.
permit?
Good question. If you are going to disturb bed and banks in that repair or modifications to that structure, yes, you do need a stream alteration permit. If you're just doing, adding concrete or doing something to the structure without affecting bed or banks, no, you do not.
Also,
However, I back up there. Any of your modifications that you do cannot impact the ability of the stream to handle those flows.
Also, what about like if a tree falls or the beaver dam or there's some kind of natural occurrence of trash, garbage in the stream? Is it okay to go in there and remove that?
Yes, typically if you're removing woody vegetation, you're not altering the bed or the banks, yeah, you can go and remove trees, you can remove, like you say, beaver activity without having to get a permit. Any other questions?
What about just crossing, going through a stream with machinery?
There again, technically, if you're going to alter the better banks of the stream, yeah, that's the answer. Pipelines that are going, pipelines or fiber optic cables, anything like that you make a crossing, typically you need a stream alteration permit. If you're just going to drive your pickup across it and it's really not going to do anything to the better bank, I'll leave that up to you, I guess. But yeah, if you alter the better banks, that requires, okay.
Is there a difference in the permits required if it's on federal or state or private ground?
No. Other than you may have to deal with those other agencies to gain access. But for our requirement, no, yeah.
Would it be possible for say there are multiple people who are doing work in the same location on a stream, a federal agency and a private landowner are both reinstalling and installing diversion works. Can it be under one applicant?
The answer, I guess, there is yes, because we saw that happen in St. George in the 2005 flooding events that took place there. I'm not even sure what agency it was that actually filed the stream alteration applications, but it covered, they did a lot of work up and down that stream to shore up the facilities and the structures and to put riprap in. But it covered more than one entity or owner. So yeah, it is possible. But whoever files that application becomes the responsible party. I hope I was right there. Any other questions? All right. Let's move on to groundwater recharge and recovery. This is an aerial photo of Sand Hollow Reservoir down in Washington County. Some of you may be familiar with that structure. It receives water from the Virgin River. It is also the site that the Lake Powell pipeline will end up dumping into. This reservoir was constructed over a sandstone formation. And they knew that when they built this, that it would leak into that sandstone formation. So the Washington County Water Conservancy District filed a recharge application as well as a recovery application. And through that process, they gained approval to recharge and recover that aquifer system. The points in red you see there are wells locations where they have wells that they can pull water out of the aquifer system that they have recharged into that system. Okay. The most important thing here is a person may not artificially recharge an aquifer without first obtaining permission. You need to have a recharge permit. Also, a person cannot recover water that has been artificially recharged without first obtaining a recovery permit. Okay, in order to artificially recharge an aquifer, you must have a valid water right or have an agreement with somebody who has a valid water right. That recharge and recovery process, that water has to go into a hydrologic area of influence that can be recovered. Okay, for the recharge permit, among other things, You need to specify the name of the groundwater basin that will be recharged. Give a legal description of the proposed recharge project. Identify the source of the water that's going to be recharged and the amount of water that's going to be recharged. As I mentioned previously, you also need a valid water right. The quality of water being recharged and the quality of water of the aquifer needs to be identified. You need to apply for water quality permits, not just so not only through the state engineer's office, but you also have to go through water quality to get approval. And you must have a plan of operation. That plan of operation will outline the design capacity of the project. It will detail a monitoring program that will take place and outline the proposed duration of the project. You must conduct a study of the aquifer system. You need to determine the area that will be impacted hydrologically by the project. You need to determine whether or not the project is actually feasible. You need to have information that will show that the project will not cause harm to surrounding land or landowners, and it won't impair existing water rights. The project has to be both technically feasible and economically feasible. There is a filing fee associated with the recharge project. That filing fee is based on the amount of water you intend to recharge. Okay. Any questions on recharge?
This may be a little bit off of that, but what if a major ditch that feeds a system is piped? Is there anything that the state engineer looks at in relationship to how that ditch leaked and recharged the groundwater? Do they do anything in relationship to that? If 4 miles of ditch is piped, do they look at the recharge factors and make them, add water to the ground or something?
No. The state engineer won't look at that. I suppose if you want to consider that a recharge project, maybe the company can look at filing a recharge application. However, I think you'd have a problem meeting all the requirements there, probably with the water quality and so forth. And then you'd have to have pretty significant connection there to be able to, I don't know what the point would be to file a recharge application there.
Well, where I'm from, I have a lot of concern about a lot of commercial people or piping ditches and stuff. And
Yeah.
I just worry about people that have wells and, that have been there for 20 years.
The impairment due to their
Yeah.
activities of piping their ditch.
Yeah, we have ground drying up everywhere because people are piping their
And
ditches.
that happens all throughout the state. The advent of sprinkler irrigation has greatly affected return flows into systems. Now all that water is being consumed through the sprinkler systems and no tailwater is making it down to lower users. Those are issues that really can't be addressed through the water rights process. You can't force somebody else to be inefficient in the use of their water so that you get what comes off there.
Okay.
Any other questions on recharge? Okay, let's talk about recovery. A recovery application can be filed along with a recharge application. That recharge or that recovery application must give a legal description of the wells where you intend to pull water out of that aquifer system. You need to identify the purpose of why you're recovering that water and what you're going to be using that water for. You need to have information on depth, diameter of the well so that we make sure it's in the same aquifer system that's being recharged. We need a legal description of the land where the water will be used, as well as the design capacity for that system. There is a filing fee for a recovery application, which is $2,500. The filing fee for the recharge is significantly less than the recovery. Like I say, typically the recharge, we're talking probably a few hundreds of dollars, but the filing fee for the recharge typically ranges less than $1,000, but the recovery application is a set fee of $2,500. Along with the recovery application, the state engineer has to set up a monitoring account, which will monitor the amount of water recharged, amount of water recovered, and amount of water lost to the system. So, for instance, that Sand Hollow project, they measure the inflows into the reservoir. They measure the outflows they take out of the reservoir. They actually have evap pans set up around there, so they measure the amount of water being evaporated from the system. And with that, they calculate a mass balance where they know what is being recharged into the system. Then any water that they are taking out of the system also has to be measured and accounted for. That monitoring program is set up through the state engineer, and we keep track of that. There is a small fee assigned each year to cover the division's cost in managing that account. Any questions on recovery? As far as there may be a few, the one I specifically know about is the Sand Hollow project. There may be one or two up north here. I have dealt with a lot of just recharge applications where they're just trying to recharge an aquifer that is over appropriated. That's happening a lot. And I think you'll see a lot more of this taking place in the future. Okay, finally, reuse of water. When we think of reuse, that's not exactly an appealing thought, I guess, but it is something that is taking place to one degree or another. I don't think there's anywhere in the state that's maybe reusing it to this point, but the potential is there. Any public agency who owns or operates a publicly owned treatment works that treats water from municipal uses may apply to reuse that water. Okay, the reuse is dependent on some conditions. The water right must be administered as a municipal water right. The reuse that takes place must be consistent with the underlying water right. And the public agency must receive approval from both the Water Quality Board and the state engineer. If the city does not own the underlying water right, they can contract with the owner of that water and gain permission to reuse that water. If that underlying water right is managed as a municipal water right and the reuse is consistent with the underlying water right, and again, they obtain permission from the Water Quality Board and the State Engineer's Office. To make application with the State Engineer, the application shall include a description of the underlying water right and an evaluation of the underlying water right's division, diversion, depletion, and return flow requirements. You need to estimate the amount of water that will be reused, and you need to do an evaluation of the depletion that will take place through that reuse and make sure that that depletion is not exceeded from what is associated with the underlying water right. If you can show those conditions, that you can use that reuse without exceeding the depletion of the underlying water right, and you meet all the other requirements with the Water Quality Board, the State Engineer can approve that reuse, and possibly with some restrictions there to make sure that you don't exceed the depletion limits of your right. Any questions on reuse? It's something that when I first started with the division really wasn't happening, but it more and more is starting to happen. There's a couple facilities I know in southwestern Utah where that's taken place. The important thing there is you can't just reuse that water. You must have permission from both the Water Quality Board and the State Engineer, and there's a process you have to go through for that. Why is this all important? You know, you're spending 2 days here getting all the ins and outs of water right. There's quite a lot of regulation. There's quite a lot of oversight. Well, the reason is water is our limiting resource here in the state. There's just only so much water to go around. And it's becoming increasingly difficult to find good potable water. You know, there's a lot of pollutants, contaminations, and I think it's just going to get worse. If you think things are going to get better with water, think again. It's just going to get worse. It is a valuable resource. It's something we need to protect, and it's something that requires our oversight. With that, are there any questions?
Going back to the small pond, let's say, for instance, a private owner built a pond and they owned water shares in a company, and they took water during their irrigation turn and put it into the pond. Mm-hmm. Would they need to file a change application to put that water into that pond?
Yes, they do.
All right, thanks.
In fact, I am dealing with a case right now down in the town of Rockville where the guy did exactly that. He built a pond, he put his irrigation shares in, but had no authority for the pond. So he just needs to work with the company to file a change. And I guess it's really up to the company, but I see no real issue why they can't get that approved. Any other questions?
Are the enforcement rules the same for irrigation companies as they are for individuals, the same procedures, the same?
Yes, they are the same, other than the way we look at company water is a little different. Service area of a company, it's a little harder to tie down sometimes their legal acreage because sometimes it's mixed in with private water rights. It's just a little more complex at times when we're dealing with a company. But yeah, they have to have approval for their diversion point. They have to have approval for the land that they put their water on. The only issue there is it's a little more difficult to investigate, I guess, any violations because of those complicating factors of mixing water and various things. But yeah, they have the same rules as far as what they can do with that water. The company needs to file applications for their storage ponds, regulating reservoirs. Any changes, if they put new land in, that needs to be part of their service area. They can't expand acreage. All those things apply to irrigation companies as well as private landowners. Anything else? All right, thank you.